Hi friends, this is Krish, the Urban Naxal. Today we are going to talk about India's judiciary. I get a lot of calls asking for help in getting a lawyer. Plenty of people who find themselves in various kinds of situations of injustice. Some people are being prosecuted. It happens some people are actually the ones who want to do the prosecuting, who want to go to court, who need to go to court. For example, one may need to go to court, to RERA, to consumer court, etc., to get justice against a builder who has taken away their money. So these are the kind of situations in which I get a call, 2 calls, 3 calls per day on this kind of thing. It ends up with me discussing with them what to do. How do you get a lawyer? What lawyer do you need? What kind of lawyer do you need? Now, people don't know, so I sort of walk them through the whole process. I talk them through the problem, and then we figure out whether they need a lawyer, because some of the time you don't really need the lawyer at this stage. And, can you do it without a lawyer? And in the case of some people, I say, yeah, you sound like you are quite well versed with the law, or you are able to understand and study the law by yourself. So yes, you can do this by yourself. You can appear as party in person, and it will be a very educative process if you do that. In the case of some others, I say yes, you can potentially appear, but the judiciary is very resistant to parties in person. So if you're going to High Court and you're prosecuting a case, you may not be easily allowed to appear as party in person. It is going to be a problem. Or if you are filing a PIL, the system resists you. So let us talk about the system, the judiciary. Right off the bat, what I would like to say is India's judiciary, maybe other judiciaries also, but India's judiciary definitely is one huge trade union. It is one massive trade union where it is not about the justice delivery. It is about the process and the people benefiting from the process. It is just about the process. See guys, any mechanism has to be focused on what its deliverable is. Whether it is delivering justice, whether it is delivering judgments, whether it is resolving disputes, whether it is punishing criminals who can easily be identified as criminals, whether it is keeping peace in society, whether it is effective in giving people confidence in the law and order mechanisms of the country. Whenever you enter into a contract, you are doing so with the assumption that the contractor and contractee, the 2 persons involved, for example, the builder and the flat buyer, are both going to be safe, are both going to be kept secure by the operation of the law. So the contract will be honored because both sides are afraid of the law, or are reasonably afraid of the outcome of a court case against them. That fear is necessary. This is the deliverable of the court. Or for example, suppose a family court, husband and wife want separation, want divorce, want to adjudicate the custody of the children, want to adjudicate matters like the amount of alimony, the support, or family matters where property has to be divided. Now in these kinds of matters, you need justice within a reasonable amount of time, maybe a year or 2 at the most. A person who is filed for divorce in his 20s, if he gets divorced finally in his 40s or 50s, what is the point? Or a person who has filed for child custody when the children are, say, 3 years old, There is no use getting child custody when the child has grown up to be 17 or 18 or 20. It makes no sense. Because the purpose for which the law was invoked has failed. What has happened is there is this cliche, justice delayed is justice denied. Now it has become such a cliche, it has become such an oft repeated word, phrase. It means nothing. You just say justice delayed is justice denied. Yeah, justice delayed is justice denied, blah, 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 blah. Yeah, really, it is like that. What is the use of saying justice delayed is justice denied? Even if the judges say, yeah, we have heard that all. Yeah, okay, no problem. Chalo, next. This happens. They say the law will take its course. Yeah, it takes its course like a fucking slow river. A very, very slow. It's not a river, it's a glacier. After 1,000 years, it is going to reach the destination. You get all these alarming stories of people who go to a court and a judge is very quick in delivering a judgment which is a miscarriage of justice with no regard to the facts, with absolutely no regard to the facts, with no regard to the law. Then you have to go and appeal that. Now, when you appeal, the scope of your case is already drastically reduced. So, when you first filed the case, let us say this is the scope of the case, when you appeal it, you can only argue about this much. This much you can't argue. You can only argue this much. Now, if it goes to second appeal, it becomes this much. You can only argue on law points, or you can only argue on the amount of punishment and that kind of thing. So, the law is not a perfect mechanism. That's an understatement. The law judiciary is a trade union. That's a given. It's a trade union. And nobody is trying to break the trade union. Nobody feels they can break the trade union. The fear of this trade union is so great that if you go up against this trade union, the judges and the lawyers mainly, and all the employees of the court, if you go up against this trade union, you fear that your own fundamental rights may be negated. Because someone files a case against you and the judges will very, very quickly give orders against you. So this is a little bit like, in school, you don't want to go up against the teachers and the principal. You don't want to piss off a teacher because, she will fail me in my subjects. You may be a bright student, yeah, but then many of the questions are subjective. And in subjective questions, she may mark 7 when she could mark 9. Or she may mark 3 when she can mark 6. It can make the difference between passing and failing. You can get failing marks. So yes, you are right. The teacher can fail you. Now this is the fear. The teacher will fail you. They will be vengeful. The conduct of courts, does it inspire confidence? The answer is no. It does not inspire confidence. Are judges seen to be fair? Are they seen to be fair? And the answer is clearly no. They are seen to be arbitrary or biased, and they seem to go to no trouble. I mean, they are not going to any trouble to hide the fact that they are biased. Fact. So many people will say, yeah, the judge was biased. No two ways about it. Now, it is human tendency. Both the parties are there arguing their cases. One side is going to win, one side is going to lose. It is possible that we are of course biased in our own favor. But I don't think it is a myth that judges are easily biased or that they can be bought. It is frequently said judges can be bought. I see these judgments. I see such orders myself. See, guys, judgments come at the end of the whole case. But before the judgment comes, there are a lot of orders, interim orders and so on. And sometimes the interim orders, etc., are more meaningful to you than the judgment itself, what comes at the end of the case. What happens in the interim is kind of more important or as important. For example, a rape victim, and there's a rapist, or there is a criminal who's terrorizing them. They want to see him in judicial custody. That is justice. That is the meaningful justice for them. If a gunda who terrorizes you by his very presence in your neighborhood, he's got goons who will brush past you and who will walk past you and who will laugh menacingly and who will talk, meaningfully with threats around you. And they have already harmed you or your family, and then they are allowed to hang around and be free on bail. That is a place where you have already negated justice. But that happens. It happens so frequently. The justice system doesn't respond to you. You may say, I'm afraid for my life. The justice system is very slow in responding because you are not some VIP. You are not some MP, MLA, corporator, minister. You are nobody. You are just a common man. So if you say, I'm afraid for my life, this way, the justice system says, yeah, okay. Police also has become desensitized. They say, yeah, okay, you are afraid, yeah, okay. तुम्हारा murder हो जाने दो, उसके बाद में देखते हैं. Let the murder happen. Let violence happen, let assault happen, then we will see. Under such a circumstance, it is useless to say that fundamental rights mean anything. It's quite useless to say, oh, we are functioning according to a constitution. The common man is not living in an environment where he sees the country functioning according to a constitution. The common man sees might is right. People who are powerful, there's a different justice for them. The court behaves differently towards them. For me, it is tariq pe tariq. For them, if they are defendants, it is tariq pe tariq. They will continue to get time, the luxury of time. The poor man, if he is the accuser, he is always in this position of, time is your enemy. Because the court keeps giving time. If you are a powerful person and you are accused, time is your friend. Because the more dates you get, the more you get to play around. The more you can settle. You can settle the witnesses. You can intimidate the witnesses. You can influence the witnesses. You can send people to influence the witnesses. You can threaten the witnesses. Now, if witnesses are threatened, or if evidence is tampered, is the system sensitive to it? The answer is no. If outright lies are told to the judge, absolute outright lies by the opposition lawyer, is there a punishment for the opposite side lawyer? The answer is no. Outright lies. If things are suppressed, if matters are, the facts are suppressed from the court, and false, there's the Latin phrase for this. False things are put forward, suggested, and truth is suppressed from the court. That is a form of active lying. The court is supposed to take notice of it. Will the court take notice of it? No. They will say, oh, that's just the lawyer doing his job. Lawyers are just doing their job. But are the judges supposed to let the lawyers do that job of misleading them, actively misleading them? It happens. They are doing that. Then there is another problem. Court proceedings are procedural. They are technical. They are not about the merits. The merits comes last. The merit of your case comes absolutely last. Now this is whether it is criminal law, whether it is civil law, whether it's family law, whether it's company law, whether it is consumer law, whether it is RERA or any other special act. Same thing. Most of the time, the whole thing is technical, is procedural. It is rules and not even rules, conventions, and just the way things are done around here. It is customs. It is about the customs of that court. It is about that customs of that court in that state. Customs of Madras High Court is different from customs of Mumbai High Court, and so on. We do things around here like this. Delhi High Court will function in a different way. Mumbai High Court functions in a different way. Everybody functions in a different way. Civil court functions in a different way. Magistrate court functions in a different way. You have to know the customs. That is a large part of the battle. You have to know the customs. You have to know the procedures. You have to know the way things are done, written. Now, what is the difficulty here? You may say, boss, every place has its custom, every state and every village and every district has its own customs. Every community has its customs. So what is wrong? I'll tell you what is wrong here. What is wrong here is, lawyers are not people who know the law. Lawyers are then not people who are the winning lawyer, the guy who is able to win. He doesn't necessarily know the law, or he knows the law but he wants to bend the law. He has an intention of bending the law. The lawyer is someone who has an intention of misleading the judge. And misleading by various means. We'll come to that later. The lawyer is someone who knows the local traditions. This is how things are done around here. And if one lawyer knows the local traditions more than the other lawyer, then the guy who knows the traditions more is likely to just win. Because that is the way he speaks. And the judge will hear him favorably. He'll say, this guy is speaking according to our methods, our traditions, our techniques, our procedures. The other guy, you don't know the procedures or what? You will scold the other guy. In an ideal scenario, the common man should be enabled to speak for himself in whatever language he can speak. Now, admittedly, there is a disadvantage. Suppose there is a guy from Orissa who speaks only Oriya, and he has to appear in Bombay High Court. Hindi, English, yes. Marathi, he can be heard. But if he speaks in Oriya, who will hear him? Will they find an Oriya judge? So it becomes difficult. Having a multilingual society imposes its own difficulties. So matters have to be presented before Bombay High Court only in English. Before all high courts for that matter, only in English. In lower courts, matters are often tried in other languages. In magistrate court, it's all Marathi. So, the linguistic barrier is one problem, and you have to find ways to get around the linguistic barrier, but it's not only the language barrier. You've got other barriers. They will say, no, for example, let us say you're prosecuting someone. Let us say there are witnesses. Those witnesses have to be made to testify before the court, not before the police, but before the court. And they should be made to testify within a reasonable amount of time, before their memories fade, but at the time when it is still meaningful. Ideally, witnesses should have to testify within weeks, a few weeks, maybe 2 weeks, 3 weeks, 1 month, 2 months, after an incident has occurred. If you wait for years and years and years, and if you call the witnesses and then you send them back and say, no, today we are not testifying, again you call the witnesses, again you send them back, and then after 10 years, 15 years, 20 years, the person has to testify about an incident, and then you cross-examine him and say, are you sure? Are you sure you saw this? Are you sure you didn't see that? Are you sure your memory is not playing tricks on you? It is not fair. A few days after an incident, the matter is fresh in your mind. You've seen everything. Ideally, it should be within the same week. Months and years pass, and then you call the witness and say, are you sure? Now, most of the time, the witness himself sees the uselessness of this exercise. He himself says, Listen, I am not, I don't have to appear here. Forget it. This justice system doesn't work. I am being called to give witness against a very powerful man, a criminal. They expect me to fend for myself. They expect me to continue to live. The criminal is indirectly threatening me every day. My family lives in fear because I am a witness. And the opposite side, the criminal, is now offering me a suitcase of money and saying, in case you don't appear, here is the money. It makes sense. Of course it makes sense for the witness to turn hostile. Though it is very easy, and it is from the witness's point of view, he's not a social activist. A few social activists will stand and say, no, we are going to fight and we will expose this criminal. And often they pay for it with their own lives. They die, or they are attacked, or some accident happens to them. And there's always the suspicion, oh, that guy bumped him off. And once they see that this has happened, some violence has happened to this man, all the other witnesses who are anyway getting scared, they get even more scared and they don't want to speak. Is it not the problem of the judiciary? Is this not a problem that judiciary should be actively engaging in? It should. Does it? No. It doesn't give a flying fuck. Shouldn't the Chief Justice of India care about this? The Chief Justice of India doesn't give a flying fuck. Fact. Does the Chief Justice of any High Court give a flying fuck? No. Does the Chief Magistrate give a fuck? No. He's lower down. He is closer to the problem. He sees the problem. He sees the problem day in and day out, and does he give a fuck? No, no fucks given. None. There is a no fucks given policy. We don't give a fuck. Now, if you don't give a fuck about this, what the fuck are you giving a fuck about? Where is justice? Let's talk about senior and junior lawyers. The rich and powerful engage very big lawyers. They engage senior counsels. They charge lakhs of rupees to appear in court. But when they argue, judges listen. The senior counsel may talk bullshit. The judge will listen, and listen respectfully. The other guy, the common man, engages an ordinary lawyer who charges 3,000, 4,000, 5,000 per hearing at most. And he appears. He's a junior guy. He's seen. The quality of his court will show that he's a junior guy. The way he speaks will show that he's a junior guy. And when he speaks, the judge takes him lightly. This is called corruption of face value. Corruption of face value is rampant through the judiciary, through the entire judiciary, all levels. What are we doing about it? No fucks given. Nothing. I'm Krish, the Urban Naxal. Jai Maharashtra, Jai Hind, Jai Jawan, Jai Kisan.